Hi, welcome to Module 5, where we're looking at the concept of precedents. Now, this is a concept which may at first seem overly legalistic, and certainly we're going to spend a bit of time looking at the way in which courts use precedents as a way of achieving justice. But it has a common root in everyday experience. If you've ever been in a position where you've been told that you can't do something, where you've previously been able to do it and haven't had any problems, and you've been told suddenly, no, the rules say you can't do that, that frustration with the inflexibility of a rule system, particularly the way it can be applied inconsistently, will give you an idea of where our idea of precedents comes into play as a way of softening the application of rules, and also being able to rely on, if rules are the fact that if rules are interpreted in a certain way, you have an expectation to be able to continue to see those rules be applied in that way. So precedents are not just a way of applying more flexibility and giving more wiggle room to achieve justice within a strict rules framework, but they're also a way of recognizing that that process is inevitable, that's always going to happen, but it has to be done in a consistent way. Otherwise, there's no point really having rules if you just apply them all over the place. So precedent is also really focused on that idea of being able to record somehow, being able to acknowledge a certain interpretation, and being able to use that consistently going forward, and at least to warn people if there's been a reason to change the way that flexibility has been applied. And that's why within the legal system we have court reports and we have reports of cases. We're not concerned about the facts of cases, and that's one thing that beginning law students often get stumped by, because they come into the law, and you guys possibly have the same expectations of law. They come into it with this idea that law is all about the facts and it's all about determining who's right and who's wrong on the individual cases. And they look at the law reports, and they're all these kind of obscure theoretical arguments about precedents, and they're like, well, what the hell? What's going on here? What's law all about? The majority of the business of law is done on that ground level of here's a case, here's the facts, here's the decision of who's right and who's wrong. But the small area in which the ordinary application of facts doesn't work is what gives rise to the creation of judge-made law, of precedent. And one of the examples I provide in the readings is, something like a Weapons Act, where you want to be able to define weapons in a way that's broad enough that you're not excluding things. People say you define a weapon as a broadsword, and someone comes along and says, oh, but this is a samurai sword. It's a totally different thing, and therefore it isn't covered by the Weapons Act. You want to define weapons in a way that's embracing a lot of different types of weapons, but you also have to be really cautious about over-defining things and because anything can be a weapon, really, if you are creative enough in the way in which you use it. And that's not the purpose of weapons regulation, is to, make every paperweight or phone or coffee mug into a weapon just because someone might be able to use it as a weapon. It's to focus on the possession of dangerous weapons, particularly in public places. So that's I think a really good example. There's plenty of other examples of the ways in which precedents come along to interpret those broad rules and to provide that kind of texture and that kind of context. When someone, brings along a Klingon sword, and the framers of the original legislation never thought to include Klingon swords, and the courts are then asked, well, is a Klingon sword within the definition of the Weapons Act? The rules of precedent and the existing precedents give you a structure for being able to make those arguments about the Klingon sword in a way that is consistent, transparent, and at least it's transparent up to people who have access to law libraries. I mean, it's not really all that accessible to the public, but in a way that creates that kind of certainty, so that someone who wants to go to Comic-Con and carry their Klingon sword with them can ideally by themselves, but probably with a lawyer's help, figure out whether they can carry that thing in public without invoking the Weapons Act. I also have a everyday example in the book about the bedtime rule. I'm not going to go through it here now and discuss that one, but I think that's another example which gives you a grounded idea in everyday practice that's nowhere near the law about the way in which we use precedents all the time. You know, we set rules, we set firm rules, but we also set these precedents in the way in which we're going to apply those rules. Now, this is very, very culture specific, and Anglo-American legal traditions, the common law legal traditions, have really embraced this idea of precedents as a way of moderating strict rules. There's a historical example of, there's plenty of historical examples of really strict rules. The draconian rules of Draco were rules that provided that everything had the death penalty, with this idea that the only way to regulate society was that any infraction of the rules would get the death penalty. And that's why we talk about laws being draconian now, as a metaphor to refer to the laws of Draco. And you know, our tradition has a certain abhorrence of the strict application of rules. Interesting to look in a comparison to the Chinese legal tradition, which is very much about the strict application of rules. And in fact, they have had their own Dracos in the past. They've had strict rules with death penalties for everything, which they've realized, you know, as we did, is not very effective. Largely because once you've broken a rule that gives you the death penalty, you might as well break all the others. You know, if stealing is going to get you the death penalty, you might as well murder the person you stole from, if you're thinking in a completely rational way, because you're still going to get the death penalty anyway, and if you murder them, you're not going to leave a witness behind. So those kind of strict rules, everyone's realised are a bad idea. But the Chinese legal tradition is much more rooted in very, very certain application of rules. There isn't really a tradition of precedent. And there's an interesting intercultural clash where you get someone looking at a strict set of rules, or a Western lawyer, Anglo-Western lawyer, looking at Chinese laws and going, these are really unjust because they're very, very strict. There's no wiggle room. There's no ability for me to argue my specific personal situation is different to everyone else's. But if you flip the situation around and you have a lawyer who's trained in the Chinese tradition, they'll go, what? Your Australian laws are so unjust because no one can predict anything. They're really, really unfair because everyone just gets to bring a lawyer along to court and argue that they're special or they're in a different situation. How does anyone do anything or arrange their affairs with any certainty based on these rules, which are always shifting and changing? So there's that cultural difference about what's considered just that's embedded structurally in the way in which the legal systems operate. And, you know, you can see both sides of that. As someone who is enculturated and brought up in the Western system, I do like the ability that if there's extenuating circumstances, those are taken into consideration. But I can also see the perspective that where there's one rule for one person, one rule for the other, and it's applied really inconsistently, if your mindset is really based on this sort of idea of justice as fair treatment, of sameness of treatment across the board, you're going to see our system as a bit of a mess. Jeremy Bentham, the Enlightenment philosopher, referred to the common law system as an ill-shaped heap of odds and ends, and then declared that it was nonsense upon stilts, which is one of the more bizarre but flavourful burns from history, calling something nonsense upon stilts. But he was very much in favour of replacing common law with legislation, so that anyone who wanted to know what their legal position is could look up a book. And this is and when you do your subject on criminological theory and you look at positivists, this is very much a positivist view. And again, like the Chinese legal scholar, you can see that idea that why should only the rich who have access to lawyers be able to understand what the law is? Surely you should be able to open up the big book of law and look at, well, is this legal or isn't it legal? Surely that's more just. So yes, even within our own system and our own history, there have been plenty of critics of the way in which precedent operates, but there's also plenty of support for it. And there's a concept of judicial discretion. And when we often talk about judge-made law, we're talking about these little discretions that judges have to make rulings within the guidelines of a system. Now, occasionally you get people overstating this criticism and saying it's just judge-made law, no one elected judges. How can we have this? It's so anti-democratic that judges can just go out and make law. But the truth of the matter is judges just can't go out and make law. They're confined by the existing laws, and the laws generally have these areas of wiggle room built in for them to create these precedents. So I think the term judicial discretion is a much better term than the idea of judge-made law, which seems like judges are going out and creating statutes and things which they're not. A good comparison, I think, would be the discretion given to police officers, and I guess to corrections officers as well. But there's been an ongoing argument about the amount of discretion that police officers have. And again, originally, there was this belief, and it comes from an era with very high levels of police corruption, that you don't give police officers any discretion at all, because they'll just then use it to favour people that they like or to punish people they don't like. But we saw an emergence of the idea of community policing through the 60s and 70s and 80s, where we realised that things like cautioning, giving police a discretion within the system and being able to say to someone, look, I'm not going to book you for this, but I'm going to issue you with a formal caution, and that may be something that's taken into account if you do it again. We realise that sort of flexibility made for much better policing, much better outcomes. So the idea of discretion is something that we think about across the justice system now. And, again, into things like parenting and rules for children as well. Parental discretion is something that is very important, and not requiring people to set inflexible rules. But again, you've got the critics who will say that if that goes too far, and too far by definition is too far, but if you have permissive parenting where there are no rules, that also has a negative impact on children. All right, so what is the judicial method? What do judges do when they're looking at cases? We looked last week at the rules of statutory interpretation, and we basically came to the conclusion that there had to be a really glaring inconsistency in a written set of rules in statutes before judges got any discretion at all. There had to be manifest absurdity, a clear absurdity on the way something was going to be interpreted in a certain way before a judge could come along and go, no, we really need to make our own rules on the rules, these meta rules about the way in which we use the rules. Now, that's from the legislature's point of view. From the judge's point of view, there's a principle called stare decisis, and the book will have the spelling of that if you want to look it up. Your notes will have that. But stare decisis just means let the decision stand in Latin. And hey, if you're going to do anything involving law, learning some Latin's all a bonus. So the general principle is if there is a previous decision on a particular point from a previous court, your general idea is to let that stand, because people have theoretically gone and arranged their affairs around that particular way of seeing things. And it's going to create problems if you then say we're going to apply a different rule in this case. They'll say, hang on, we've done this 5 times before and you've applied the rule in this way. Why are you applying it in this way now? So stare decisis says, unless you've got a really clear reason, let the original decision stand. It's usually more enforced where a decision is a decision of a higher court in the hierarchy. And generally lower courts are supposed to follow the higher courts in hierarchy. But it's also for courts within your own level, the judge's own level in the hierarchy. Your tendency is to say, let's stick with what's there unless we've got a good reason. The other thing that judges do is what we call distinguishing cases. So okay, we've got an existing case that says X. You always follow the rules in a particular way. Now, how much are we bound by that particular previous case? What if the circumstances are different? Now, we've got a couple of concepts I'm going to bring up here that are part of the notion of distinguishing a case, which is where we say, yes, this is a previous precedent, but this is a special circumstance, or this is a different circumstance, so we don't have to follow the previous precedent. So remember the bedtime rule, where we had a certain rule about grandma coming, and then that was being used as a precedent when Uncle Frank came to visit, that we didn't want the children to be able to use. That's a situation where you are distinguishing the precedent. You're saying, well, the precedent we said about grandma coming to visit and changing bedtime is confined to grandma. It doesn't apply to all relatives coming to visit. It certainly doesn't apply to Uncle Frank, because Uncle Frank's a real problem. So when you distinguish a case, you say, yes, we observe stare decisis. We always follow the previous cases, but we don't have to follow this one because it doesn't apply in this situation. And what you do is you break the decision into two parts. In the strictly binding part of the case, which is what we call the ratio decidendi, more Latin, and the other parts of the case that are just the facts, the general facts around the case, or things judges may have said that are non-binding, or the rest of the case, which is what we call the obiter dicta. And when we're looking at strictly speaking the rules of precedent, the ratio decidendi, the core of the case, is the only thing that's binding. All that other stuff, that obiter dicta, it might be persuasive in future cases, but it's not strictly binding. So if we're looking at the bedtime rule again, any discussion about whether the bedtime rule is modified, as a strict rule, it's about grandma visiting, and any discussion that we might have about is that applicable in a general scheme in terms of any relatives coming to visit, do we modify the bedtime rule for everyone? That's what we would call obiter dicta. That's a situation where we go, well, that's persuasive, and the kids who are saying we want to stay up late because Uncle Frank's coming to visit are able to say, we can use this as a persuasive argument, but it is not an authority that we can use and invoke and say, hey, we're entitled to stay up late when Uncle Frank comes to visit. So obviously that's a lot more complicated in legal situations. And there is always this balance between finding out what the core is of a case and distinguishing the extra stuff. So you can go too far with limiting, like if you've got a case relating to a car and you try and distinguish it and say, oh, but this was a red car, and in this case it's a yellow car, and therefore I'm distinguishing the case on the basis of the colour of the car. Generally, that's not going to make any difference to the core principle. You're just engaging in kind of pointless pedantery when you're trying to limit a previous decision in that way and distinguish a previous decision. So you really have to be able to stick to the facts. But if you've got a situation that's a decision relating to a car, and then the court talks generally about motor vehicles and motorbikes and cars, then even if they make a rule about all motor vehicles, will apply the rule this way to all motor vehicles, you've got an opening in a later case that involves a motorbike to be able to say, oh yes, but if we distinguish that case, the original case referred to a car, it only refers to cars, and it's persuasive here in a case involving a motorbike, but there are also other factors to take into account. This, at its core, is what lawyering is about at that appeal level, at that high level, high money, high cost level of lawyering. It's about this interplay between rules and precedents and being able to make these arguments that the previous precedents apply or don't apply on the basis of this process of distinguishing cases. I also want to touch on, and we're going to look at this in the workshop in more detail, the complex situation that happens when you have multiple judges on a decision, and where you have most appeal decisions have and higher courts have a panel of judges. How do you figure out, and they're all entitled to have their individual judgments, how do you figure out which rules apply and which rules don't? Because they can all come to the same or different decisions, yes for the appeal or no for the appeal, on the basis of different reasoning. and different precedents. Now, you guys don't need to know this at all for your ongoing professional work or at this level, but we're going to explore it in the workshop out of interest, and because it's kind of a fun logic puzzle, and because I think it gives you a very interesting insight into the legal mind and the way in which the law operates. So we're going to do a deep dive into what happens when you've got a series of precedents from different judges at different levels that all disagree about the way in which they got to the point. As I said, we're probably never going to have to deal with this in professional life. We're doing it as an exercise, first of all, I think, because it's an interesting insight into the legal mind frame, but also some of you guys are going to go on to do legal studies. Some of you are going to get bitten by the bug and want to do more about law later on, and maybe transfer to a law degree, or when you finish your current degree, do a law degree. And I think this is a really good introduction to the sorts of things you learn in a law degree, so that you can judge for yourself, do I want to spend 3 or 4 years of my life arguing about whether, a cow is an animal or not? Do I really want to sit down and do the matrix analysis of 4 different judges saying 4 different things and where their common levels are? Is that something that I think, yeah, that's a fun puzzle, I'd like to do a law degree? Or do you look at it and go, dear God, I never want to look at that ever again. A law degree is not for me. And one of the things, as someone who's taught law for quite a long time, is that the legal education system, accreditation system, is really focused at this high-end stuff. Most of the stuff you'll do in a law degree is this high-level judicial discretion analysis of appeal cases, even though most people who qualify as lawyers will never go anywhere near an appeal court. And this is one of the kind of bizarre paradoxes of legal education, is that most of what you learn in a law degree, while it is useful for everyday practice, is not stuff that you'll ever do or ever come back to. And that creates a bit of frustration, I think, for lawyers, because people who say, I just want to represent clients, or do I'm going to say do wills or do mortgages, but other people do those things now. But I just want to work in a legal office, deal with people, whatever else. And you spend most of your time looking at what justice someone said in 1784 in this appeal court case. So yeah, in some ways, the study of law is very arcane. It's very kind of Hogwarts in many ways. But in other ways, getting a grasp on how this works is really important for people who are working on the ground with policy. And I've watched the debates around, for instance, the overturning of Roe versus Wade in the United States. Obviously a big political issue with important consequences, but people are discussing it as though the courts just come into this situation and just made an arbitrary decision and just said, oh, we don't like it anymore, we're just going to get rid of it. And they didn't do that. Now, you may not necessarily agree with the way in which they went about overturning the decision. You may not agree with the result. That's fair enough. But you need to be able to understand how they went about and doing it in order to understand what its implications are, rather than thinking it's just that idea that judges wake up in a particular mood and go, whatever, we'll just get rid of that one, or we'll change this one because I want to, or because that's the way my politics lie. That stuff influences it. But at the end of the day, there's a whole legal process that has to be used. So again, as usual, we'll talk about this more in the workshop this week.